Hi, y'all, and welcome to tonight's live stream. From our chat here on the channel, I think it's a pretty safe bet to say that the overwhelming majority of people believe that Donna Adelson is guilty of conspiring to murder her ex-son-in-law, Dan Markel. So the evidence does look very damning. It's very easy to assume from Charlie's trial that her upcoming trial is going to be exactly the same, that it's going to be just a formality on the way to her being convicted. But this week's final pretrial hearing may have very quietly changed a lot. It has huge ramifications for the way Donna's trial goes, and it's going to be very different from Charlie's. Plus, we got not one, but two different confirmations that Donna Adelson is going to testify. So with jury selection now 11 days away, Donna's defense team walked into court with a very targeted list of motions, and they won several key rulings that could reshape the way the case gets put on. Donna's team was far more prepared than Charlie's was because they've had the advantage of seeing the trial go through once before. So they've seen the state strategy and what's going to happen. The defense team has gone after a number of pieces of evidence that they think help the state the most. Like, for example, that massive Wendi, Dan Markel divorce file. The state witnesses giving opinions about emails and things that Donna Adelson did. And by no means did Donna Adelson win every motion. She lost some critical motions, but she made some substantial inroads. What we're going to be looking at tonight is what are those, and will it be enough to tip the balance in favor of Donna at her trial coming up? So let's get started. Let's talk. Special shout out to our first five in tonight's chat: Coach Margaret, Melissa, Michelle B, Maria Z, and Oklahoma GG. Welcome to all of you. Also, I'm going to be doing something a little different tonight. I've never really talked about an affiliate link before, but August is National Make a Will Month. And if you don't have a will, this is your sign to stop putting it off. I personally am a huge procrastinator. So my dad moved in with me more than 2 years ago. And since he moved states, I can't tell you how many times I woke up in the middle of the night and wrote myself an email, get dad and you will. And I never did it. I just put it off over and over again. You think, oh, well, Lee's a lawyer. This is going to be really easy for Lee, but it's very much not. When I was in law school, I made a very deliberate and intentional decision. I never took a wills or estates class. I don't ever want to do that. But so I knew we needed a will, but I really honestly did not know how to go about doing it. So earlier this summer, we used LegalZoom. And it walked us through everything we needed to do. And then just bam, they sent us this beautiful packet of printed out documents. I took my dad over to UPS and we got it signed and notarized for $12. So it was just a huge load off my mind. And you need a will too. I don't care how old you are or how much money you have or whether you think your family is just sure they know what you want. If you die without one, the state gets to decide all kinds of things, like what happens to your money or your property or your kids, depending on how old they are. And it can be hard for your family to do even some small things like sell the car or much less, big ones like sell your house. So it can cost your family a lot more. It's a mess. Don't do that to your family. And right now you can get 20% off for Make a Will Month at LegalZoom. There's an affiliate link in the description below. It helps support this channel if you go through the affiliate link. So be sure to do that. Be sure to make yourself a will. So, all right, let's take a look. Excuse me. All right, so what I want to do tonight is take a look at the hearing and what some of the key critical rulings were at the hearing that we just witnessed today for Donna. I've got clips for you. Sometimes I'm going to talk you through them. Sometimes they're a little hard to understand. I did various ChatGPT and I worked on making the sound a little easier, so hopefully you will be able to hear a little better. we will see. So let's get started. And let's start with, you may remember from Charlie's trial that the fact that Wendi Adelson and Dan Markel, and of course, I realize at this stage that I have given you, if you are new to this, you're wondering, what is she talking about? The person who was murdered was a law professor, Dan Markel. He had been married to Wendi Adelson. The person on trial is Wendi's mother. Wendi's brother has already been convicted of hiring 2 hitmen through his girlfriend to kill the law professor, Dan Markel. So obviously, the fact that Dan Markel and Wendi Adelson got divorced is coming into evidence. The fact that they had a very bitter custody dispute is coming into evidence. But you may remember there was a classic moment during Charlie's trial where Georgia Kappelman, the prosecutor, dropped this massive file on the witness stand in front of Wendi Adelson, and it was the divorce document. So I cut out a lot of paging through, but as you watch this, I left in the part, because you don't want to miss this, where Charlie starts to grin about this and then realizes, oh, wait, he better not do that, better swallow that grin. So let's go ahead and add it to the stage.
Just kind of thumb through it and tell me if you recognize it.
Sure.
Do you recognize the exhibit?
I do.
Is it a fair and accurate copy of your divorce file?
It looks like it, yes.
All right. And is it fair to say this was a contentious litigation process that you had with your ex?
It was.
And I want to ask you about a specific filing in there. It's on page... But if you'll just kind of thumb through it and tell me if you recognize it.
Sure.
Do you recognize the exhibit?
I do.
Is it a fair and accurate copy of your divorce file?
It looks like it, yes.
All right. And is it fair to say this was a contentious litigation process that you had with your ex?
It was.
And I want to ask you about a specific filing in there. It's on page...
Okay, so I'm going to stop it there so you can so did you notice Charlie in there with his grin? When he started to laugh, it was like, oh, he looked to the side like, I'm going to get in trouble. I better not do that. And so the entire point Georgia Kappelman was trying to make is this is a huge file, and she dropped it there. It was partly show to say, look, jury, look how big this was. I'll be honest, from a lawyer standpoint, that's not that big a file. That's actually really small, I would think, for such a contentious divorce process. But Donna would like to make sure that that doesn't happen again, right? That Georgia Kappelman doesn't drop it on there. She's going to kind of win, but she's also going to lose thanks to a very clever move by the prosecutor, Georgia Kappelman. So here is what Donna's team is asking.
It's our position that the vast majority of the court file, even with the court taking judicial notice, is inadmissible. It's irrelevant. So we're asking that, aside from very limited number of items that the state can establish has relevance, and it's not barred by hearsay, we're asking the court exclude that file.
Relevance, Judge.
So the defense is saying, look, this file isn't relevant. It wasn't Donna's divorce. This was a divorce between Wendi and Dan Markel. And there's no proof that Donna even knew about most of these documents in here, most of these things that's been filed. And a lot of it besides that is hearsay. So the prosecutor, Georgia Kappelman, is going to explain, well, half the point is that it's this massive file, that it was bitter, that it was contentious, that everybody was fighting it. It was nowhere near over.
It goes to the motive, the level of intensity of this litigation, the volume of the paperwork suggests that it was very litigious and went on for some time. The words that are used are strong, even hateful. And this was a cause that was adopted by the defendant, as the emails evidence will show. So it's important for the jury to understand the foundation of this motive is this litigation that began with the divorce, continued beyond the divorce with the child custody issues that developed later.
All right. So in part, the volume of what occurred over the divorce proceedings, you want the jury to recognize this goes to motive in some way.
Yes, Your Honor. In reference to hearsay, the items are not being offered for the truth of the matter asserted. There obviously was a litigious divorce, but it's being offered to show the effect on Ms. Adelson.
There's no evidence in those emails that those pleadings were shared with Mrs. Adelson. And so certainly, if the state's theory is that it goes to the motive, and that's their way of getting around hearsay, they have to establish that the pleadings were sent to her. My review of the emails show that did not happen. So they can't go to show my client's motive if she didn't receive that.
So the court decides, well, that's actually a pretty good point. If Donna had no idea that these were being filed, it doesn't really matter how many of them there were, how big the notebook was, how bitter it was. If she didn't know about it, it's not relevant to deciding whether or not she is guilty of murder. So here's the court on that topic.
The pleadings themselves, if they're being offered not for the truth of the matter asserted, but to otherwise demonstrate motive or intent, those are admissible. However, Ms. Kappelman, as to the bulk of the file itself, I do believe the defense is raising a clear point on this. Absent a connection or a nexus between the defendant and specific aspects of the divorce file, what is your argument concerning it?
So the judges turned to the prosecution and Georgia Kappelman and said, okay, that's a pretty good point. If she doesn't know about it, it's not really relevant to her. What's your argument here? And so Georgia Kappelman is going to do such a smart move here. She is about to lose. The judge is telling her, I'm not seeing this connection. You're going to have to prove that. And that's not something she can show. So that's when instead she comes up with a compromise, an alternative right there on the spot that gets the majority of what she wanted.
Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant. May I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstrative. You may also ask questions that generally deal with the amount of filings and also the volume of the case, but ultimately as to responses for production or mediator notices, I'm inclined to agree with the defense as to that point. There's not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case.
So in this particular case, Donna Adelson technically is winning this motion because the prosecution is not going to be able to put all of those things into evidence. They're not going to be able to go out with the jury at the end. They aren't actually admitted. But the state really is winning because one of the primary points of the file was not the file. I mean, Georgia Kappelman never planned to go through each document and say, what about this and that? And, here's a mediator notice. That isn't even what she wanted. What she wanted was to show just the volume, the intensity of what was happening between Wendi Adelson and Dan Markel. She's still going to be allowed to do that. And that was a really smart move right there on the spur of the moment in court. So now, of course, the judge throws in, judges almost always do, that things could change at trial depending on what comes in and what some of the things that actually happen are. So the defense had also filed a motion to exclude some testimony from a potential witness, Sarah Youssef, college friend of Wendy's. And Sarah would have said that she knew that the divorce between Wendi and Dan was very contentious, that in fact, Wendi had sent her some of Dan's filings that have been really harsh. But far more important for Donna's case, Sarah Youssef apparently would have said that she attended a birthday party for Wendi's older son just shortly after Dan was murdered. And she overheard Donna talking about Dan Markel, her ex-son-in-law, now deceased. And she heard Donna say, they're talking about him like he was a beloved professor, but you know something? He was a jerk. So Sarah did not testify at Charlie's trial. She said she came forward with this information after Charlie's trial because she heard the victim impact statements from Phil Markel, and she was moved to tears by that, and she wanted to help the Markels. But the state took this off the table, so the judge never even ruled on this motion, just said, we don't really have any intention of calling her, so there's no need to address that. Now, Donna's team had also filed a motion about another witness, Stephen Webster. Webster is an attorney. Just before, in the months before he died, Dan Markel met with Stephen Webster in May of 2014. He died in July, and spoke to him. He also, by the way, spoke to him on the day he died earlier in the morning before everything happened. And Webster says that Dan Markel came to him and told him that he had been on the phone when he heard, and he was trying to talk to the kids, he hears Donna say, "Stupid is on the phone." And the defense argued, he should not be allowed to talk about that statement because it's hearsay, and it's because it's Dan Markel isn't here, so he can't say what was said. And also, you're not an expert, you, Webster, are not an expert in domestic law. There's some other things he said as well. So the state said, okay, we agree Webster should not be allowed to give an opinion about what was going to happen or about the things that were happening in the divorce case between Dan Markel and Wendi. One of the things he said at the trial of Charlie Adelson was that when Dan Markel came to him, he said, I'm not a divorce lawyer. I don't do that. And Dan said, that's okay. I'm a law professor. I can help you with that part. I need somebody who's good at trial. And that's why I've come to you. So let's go ahead and hear a little bit more.
I agree with some of the defendant's motions. I don't think Mr. Webster can offer opinions. For example, his testimony, of course, will be governed by the same rules of evidence that every other witness is governed by, but he does offer some relevant points. So I think I should be permitted to, I don't know, these motions kind of blow my mind because it's like we want to pre-litigate every statement, including potentially objectionable statements that can be addressed during the trial by a proper timely objection. So I would ask that it be handled in that way.
So what you're hearing is Georgia Kappelman agreeing, right? She's saying, yeah, okay, we agree. He can't offer opinions. He's not being offered as an expert, so we're not going to have him do that. So it sounds like everybody agrees. And you might think, well, the prosecution doesn't really care about this motion, then it's really no big deal. They just said, yeah, sure, we would never have done that, or it's not something that would come in anyway. But I want you to listen to what Webster said at Charlie's trial, because I think this part is not going to come in at Donna's trial, and I think it's a pretty big deal.
And there was some suggestion that Dan Markel was expected to lose all the filings that were currently pending at the time of his death, and Wendi was expected to prevail on everything. Do you agree with that assessment?
You mean like with the contempt and all of that?
Yeah.
No, I mean, I would not have got involved if I thought he was going to lose on the contempt. You know, my reputation travels with my clients too if they're doing things like that, right? I mean, if you're representing a client who is disrespecting the court, you know, it's hard not to feel like that's bleeding off on you and you're disrespecting the court. And in Tallahassee, Florida, if you practice in this circuit, you know, if I disrespect Judge Everett today, you know, every judge in this circuit that matters to me is going to know about it before lunch tomorrow. And it's just, no. So no, I would not have accepted. That's why I didn't think I was going to take the case when I read all that.
And seeking contempt is kind of a big deal amongst lawyers right?
Yes, I mean, contempt is, it's an ugly, it's a very ugly kind of prospect. And as a lawyer, that was one of my main concerns. Is she was a lawyer, and I did feel like she should be held in contempt. She didn't disclose things on her financial affidavit, and Dan convinced me of that.
Okay, I forgot to ask everybody, would you please hit the like button? That'll help YouTube know we're here. Also, if you're not subscribed, please do. We would love to have you. So you hear what he said there? That's a pretty strong opinion. He said that he felt like Wendi should be held in contempt. Based on what he saw, she did not disclose things on her financial affidavit, and she should be held in contempt. His client, Dan, had convinced him of that. He also said that he felt like it was completely wrong, the idea that Wendi was doing well, that she was going to win, that actually he felt like Dan was doing really well and Wendi was about to get slammed. So that is a very strong opinion. And in my opinion, the judge's ruling says opinions like that can't come in. Now, there's always, we'll see what happens at trial with anything like this. Everybody can raise that again. But to me, that fits classically into what the judge is saying. Yeah, we're not going to have that. You're not going to be allowed to say that. He even vouched for his opinion. I mean, when he went into, here's what would happen to me if I were to take that, and if I were to take that and and he's, by the way, he is absolutely right. You absolutely don't want to take a case when you feel like your client is going to get slammed, because it will affect your reputation. He's 100% right. But being allowed to say that in front of the jury is another issue. And so that, I think, will, to me, a lot of what you just heard will not be allowed in at the trial under what the judge just ruled today. We'll see. The prosecution suggested, well, he's not going to give opinions. I would count those as opinions. So we will see whether or not they actually come in next time around. All right.
And
Right. Concerning the testimony of Mr. Webster, Mr. Webster, in his capacity of representing the deceased, certainly can testify factually as to what his involvement was with the divorce case. And also, he may testify concerning the nature of the proceedings as to any opinions that go beyond that. Ultimately, I think that's where we are going to have to get into what is being asked and what would be the response that ultimately the defense would find objectionable. But generally, as to any opinion that Mr. Webster cannot give without a proper foundation, I think it's settled as a matter of evidence that no witness gets to generally opine on matters in which they are not qualified to testify to.
Okay. First of all, I need to say thank you to Regina Edwards. Thank you for gifting 10 Lawyerly memberships. That is much appreciated. So it ends up with not a completely clear ruling. And like I say, all bets are off when trial comes around. Everybody can, in the heat of the moment when things happen, can argue, yeah, now it comes in, or now it doesn't come in. But I think the judge is inclined to prevent the witness from saying the kinds of things that he said at Charlie Adelson's trial. So the defense also argued that Markel's statements to Stephen Webster, like what he heard Donna say, that's hearsay. The prosecutor and the judge seem to agree. So that would be a significant loss, that comment that Donna supposedly said about stupids on the phone.
I agree in general that those statements would be hearsay. I don't recall what my theory of admissibility was in prior trials, but I would agree to approach, if I intend to elicit a statement made by Mr. Markel to his attorney, and offer my theory of admissibility prior to asking the question.
Well, as a general principle of evidence, hearsay that has no exception is not admissible. If the state is seeking to admit this statement for a proper purpose that actually has a basis in the rules of evidence to be admitted, you will need to approach so that way the information is not placed improperly before the jury. The motion of remedy is granted as to Mr. Webster offering any opinions for which he is not qualified to give. The court will reserve ruling on the issue of any statements that he may testify to by the deceased.
So we'll find out what happens at trial, but it really does sound to me like this could be a significant loss for the state if they aren't allowed to put that comment in. Now, for over a year, the two sides have been battling over whether or not the words Latin Kings comes in at trial. Now, Latin Kings are a gang located in South Florida, maybe many other places as well, but particularly in South Florida. And according to the defense, Luis Rivera, one of the two hitmen, was a member of the Latin Kings gang, and not just a member, he was the leader of the entire gang. But there's a little twist here, which is they want to be able to put that information into evidence even before Donna Adelson testifies. So going back to what some of the evidence was at Charlie's trial, there was something called the bump. And that's where an undercover agent went to Donna Adelson and said, yeah, we know you took care of Sigfredo Garcia using his nickname and Katie, and you need to take care of Luis too. You need to take care of our guy, and gave her a demand for $5,000. And at that point, the law enforcement was listening. They had done wiretaps and they were listening to see what happens next. What does Donna do? Who does she go to? And as it turns out, she went to Charlie, who met with Katie Medbanwa and in a restaurant. And then that was taped by wire as well. So there were multiple layers in which they followed, phones, as well as there was a recording of Donna being handed the note. And then of course, a recording within the restaurant where Katie and Charlie met. So the defense says the reason that Donna reacted the way that she did, and the reason she went to Charlie and was frightened by this, was because she thought this and understood that this was someone in the Latin Kings gang, which in Miami is a far more dangerous gang and more frightening. So she was reacting out of fear, not out of guilt. And that's one of the arguments that the defense plans to make at the trial. So let's hear a little bit about that. Marlon has asked about where the link is that I mentioned to LegalZoom, the affiliate link, and it's in the description, and I've also put it in the chat, and Marlon can put it in as well. All right.
This goes in part to the theory of the defense and why Mrs. Adelson acted the way she did, the language that she used on the 2016 wire calls. Typically, I know that we would want to have the foundation laid through her testimony for that, but if the court were to bind our hands in questioning the state's witnesses, it would be too late to wait until she testifies. We would lose the ability to cross the state's witnesses on that issue. It's very limited. You have Luis Rivera. There will only be a few questions at most. Potentially Charlie Adelson, depending on when the state calls him. Certainly Special Agent, I believe it's Jimenez.
So Luis Rivera has testified in every trial so far and is expected to testify against Donna Adelson as well. But the state doesn't want anyone to know that Luis Rivera is a member of the Latin Kings, much less a leader of the Latin Kings. So the fact that, here's the argument being made by the state.
The fact that he was a leader of a specific gang, I think, is just bad character evidence that doesn't lend anything additional, more prejudicial than probative, and I would ask to exclude those details.
So saying basically it's going to make him look bad, and there's no real reason for it. It's just entirely and solely in order to make him look bad. There's no other reason to even have that questioning. So the judge says, okay, well, I'm going to keep it out, but if anyone opens the door by mentioning the Latin Kings, it's in. Here was his expression.
Once the horse is out of the barn, it's out of the barn.
And the defense is going to be allowed to cross-examine Luis Rivera on whether he was a member of a gang And everybody noted that one of the law enforcement officers last time specifically mentioned that he was posing as a member of the Latin Kings gang. That was his role when he did the bump. That's his character as he approached Donna Adelson. Although he never actually used the words Latin Kings. He just, I guess in his mind, felt that that's where he was. So the defense is going to be allowed to cross-examine Luis Rivera on the issue of whether he was a
As
member.
far as any cross-examination of Mr. Rivera specifically, the defense may cross-examine Mr. Rivera as to his role as a gang member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the killing of Dan Markel.
So the court says, okay, but what do we need to do about that undercover officer who walked up to Donna? Because that's a little different, because he did say he was acting as a Latin Kings member. And so they're going to discuss that next.
He specifically approached the defendant as a Latin King member, correct?
No, sir. My recollection is, I know that was his testimony, but I would instruct him not to say Latin King in the future. However, he didn't say anything to Ms. Adelson about being a Latin King. I guess that was his version of acting like a gang member. He did not represent himself to her verbally as a Latin King gang member. He was not wearing any clothing or other signifiers that he was a member of a specific gang.
So the judge and the defense both point out that he specifically said his job was to act like a Latin King gang member. Here's what he said. Here, they're going to read the testimony.
Portraying a Latin King gang member, and I was instructed to conduct the bump. Continuing on 1068, question is, all right, when you say you were posing as a Latin King gang member, did you announce yourself as a Latin King gang member to the person you approached? I did not. Okay. So you're just, that's the role. That was my role. You're a character. That is correct. In the previous hearing last year, Your Honor questioned whether there was a difference between a Latin King gang member and simply a gang member. The answer is absolutely. In Miami, in South Florida, there is absolutely a difference between a gang member and a Latin King gang member.
And here is where we got a really big piece of news. So the judge asked a really important question right here. And the judge said, okay, well, who exactly is going to testify that Donna Adelson thought this was a Latin King member? And then we get the very first mention from the defense that Donna Adelson will plan to testify at trial.
Even with that being said, this ultimately goes to your client's state of mind. Who is going to establish how she knows the difference between, forgive the pun, the garden variety gang member and a specific gang member?
I think between her testimony and anticipated testimony of Charlie Adelson.
Well, as to the questioning of the former undercover officer or special agent Jimenez, I will permit the defense to question the former special agent as to whether he is portraying a member of a specific gang as a part of his bump operation.
So right now, this is sort of in an awkward posture because the prosecutor said, I'm going to instruct him not to use Latin Kings anymore. He just kind of made that up right there on the spot. So I'm going to tell him, don't do that. But now the defense is allowed to ask him, isn't it true you were portraying a member of the Latin Kings gang? So if he then says no, I think the defense can impeach him. Well, isn't it true that at Charlie Adelson's trial, you said right here that that's who you were and that's who you were portraying? So I don't know. It's going to be awkward at trial. I don't know exactly where it'll all shake out. So as to Luis Rivera, they're only allowed to ask about whether he's in a gang. They aren't allowed to talk about a leadership role, if that's what they call it.
As to Luis Rivera, the court's ruling will remain the same as to his leadership role or specific affiliation. The fact that he is a gang member may be inquired into, and the fact that he has had or the fact that he had, or his role while he was recruited in this case, that certainly is right for cross-examination and may be inquired into. But as to him being a specific Latin king, that is where the line is going to be drawn.
Okay, are you ready for mention number 2, that Donna Adelson is going to testify at trial? Because there were 2 today, so you're about to hear another one.
So the concern we have, Your Honor, is that Mrs. Adelson, part of her state of mind, her level of fear, is that it's not just that she learned he was Latin king, but that he was the leader of one of the branches of the Latin kings in South Florida. That heightens her fear. And of course, she will testify to that.
I cannot make her testify. If she is committed to do so as a part of her defense, that's her choice. But ultimately, someone with competent knowledge has to testify to this fact. Eliciting information about state of mind from the witness that either has not spoken to your client or either has no knowledge of the state of mind, I'm not sure how that can be accomplished other than either your client herself, her son, or someone else who has direct knowledge of her state of mind at the time, unless you have an argument.
So that's absolutely fascinating, because we are getting direct intel from the defense that they plan to bring Donna Adelson. They plan to put her on the stand. What will that be like? I think it's going to be pretty different from Charlie's. Remember, Charlie was very polished, very smooth. He had an answer for absolutely everything. But in the end, the jury didn't buy it. The jury just didn't believe all those polished, pat answers. So how will it work with Donna? What will she be like on the stand? What will her answers be like? But here again, the defense has said, well, Donna can talk about and will talk about her fear from the Latin kings, her fear because she had heard that this hitman was a leader of one of the branches of the Latin kings. And therefore, she was more afraid when this bump happened. That was why she was acting the way she was, not because she was guilty in any way. So that's going to be their argument. And they said, Donna's going to testify. And the judge is like, whoa, I can't make her testify. That's her choice as to whether she testifies. But I can tell you there has to be some support for this argument, this evidence, this question that you want to ask. If you don't have the support, I can't let you ask this question. And so at that point, the defense comes up with a plan, which the judge approves. They're going to keep Luis Rivera around after he testifies for the state. And then the defense can bring him back if they want to ask him about this leadership role and if they have laid the proper foundation to do that. So that would mean Luis Rivera would testify twice if that's actually what ends up happening. So Donna now wins the very next motion in limine too. This is about interpretation of emails and recorded phone calls and text messages. The defense is complaining that the detectives are being asked to interpret emails, to interpret text messages, things that Donna did. And I will say that was actually something that did happen in Charlie's trial. So they're saying they're going to ask the court, let's keep all of that out. Let me say thank you, by the way, to Jackie P. Thank you for gifting 5 Lawyer League memberships. Jackie is a regular gifter. Many of you probably owe your memberships to Jackie. Thank you.
We're asking the court, because it has come out so frequently, that the court prohibit the state and, what's good for the goose is good for the gander, the defense, from asking someone other than an expert to offer an opinion about what someone means by an email, what they meant by a statement, or what they meant in a text message, aside from the language that's used itself.
Ms. Cumberland, response?
I agree, that would not be admissible.
The motion in limine is granted as previously raised in the argument on this matter. Any matters that would go to a code in which a witness could lay a proper foundation on this issue. Certainly they may testify as to that point, but any general opining as to what an email, a phone call, or a text message means will not be permitted unless there is a proper foundation that can be laid by that witness.
So this could be a pretty significant loss for the state. It's really going to depend on how it plays out at trial and whether or not this proper foundation gets laid. So huge next motion, which Donna lost. This is about the travel as consciousness of guilt. We've talked about this several times on the channel, where she was apprehended as she was about to board a plane on a flight, a one-way flight to Vietnam, which she had researched and which we know from phone calls. We covered those last video. Those phone calls, she talks about how she selected this country, and it's a non-extradition country. It does not have a treaty to send people back to the U.S. for trial. It can still happen. It's just more complicated. It's more difficult to make that happen. So what she wanted was that to be out entirely. There was a motion made a year ago before Donna was supposed to have her first trial, and the defense lost. Donna lost. So at that time, they were arguing, so what if she left? Because there was no rule that said she had to stay in the U.S. There was nothing wrong with that. She had not been, it wasn't like she was fleeing from justice. There was no arrest warrant for her. She had not been charged with anything, so it was okay. Now the defense added a number of additional points. For example, she did not know that there was a warrant for her arrest issued just right before she left. Detective Newland told a friend of theirs, the Adelsons, that the Adelsons could leave the country if they wanted to. And Miss Adelson's attorney, Descalzo, not Daniel Rashbaum, told Adelson, you can travel. And also Descalzo had an agreement with the state that if a warrant was issued, the DA would allow Donna to self-surrender. She could just walk into the Leon County Detention Center at a time of her choosing. I mean, reasonable in approximate time frame of when the arrest warrant was issued, but it wouldn't be necessary for the police to go to her house, clap her in handcuffs, and drag her out in a police car. She would walk in of her own power, and there she would surrender. And they had agreed to that. Those are all pretty strong arguments, but here's how the court is going to rule on this.
These matters go to the weight of the evidence and not the admissibility. The jury, as the trier of fact, is going to decide what significance to give to the evidence. The defense also is free to cross-examine on all issues that pertain to Mrs. Adelson being free to travel. The matters that have been previously raised within the motion to suppress and ruled on as to the phone calls and other evidence, that also will be presented to the jury as well. They will make up their mind.
So the court's saying, look, those are fine arguments for the defense to make. Feel free to cross-examine everybody and say, didn't you tell her she could leave? Didn't you say, wasn't she free to do that? Was there anything wrong with her doing that? Those are all arguments you can make, defense, but I'm not going to keep it out. I'm going to let you make those arguments. The state can put up the fact that she bought this one-way ticket, that she researched a non-extradition country, and then the jury can figure it all out. They can sort it out. So it's a tough loss for the defense because this is a new piece of evidence that applies to Donna that did not apply to Charlie. So it's something new and different, and it's obviously something they were aiming to keep out unsuccessfully. So as far as opinion testimony, the final, I think this is the final motion in limine, there were a couple of detectives, Jason Newland and Patrick Sanford, who had offered opinion testimony about that brand new evidence about which we know, frankly, very, very little. A lot of that has been redacted. We do know that there was an investigation by the state. We know that Donna started part of it, and then there was an investigation, and it seems to have, despite the fact that it's redacted so heavily, but it seems to have something to do with the idea that Donna was trying to get witnesses on her side. Apparently, that is not something the state plans to pursue, and so, or at least not much. And so the opinions about these detectives or investigators about what happened. Now, Georgia Kappelman said, look, we were never going to submit these opinions. This is all kind of made up. The defense took the depositions and asked them if they had opinions, and they gave these opinions. It was never that we tried to submit these.
Defense elicited personal opinions of these witnesses at deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Well, Ms. Kavanagh, even though it might be inquired into at deposition, ultimately, if there's a basis to exclude it pre-trial, that's why it's being raised now.
Of course, there is no reason to elicit it at deposition, and it could never be admissible at a trial. So we're just wasting paper and time, these motions. No objection.
But the state is conceding the issue. The motion is granted as to any opinions that would be offered by either investigator Newland or Special Agent Sanford. Again, there must be a proper foundation for them to offer an opinion on a subject. If they don't have the ability to do so, it cannot be presented as a part of the case in chief.
Your Honor, we're also
And one last thing that I don't want you to misunderstanding is apparently Donna is expecting a large contingent of supporters at the trial. They talked about, Georgia Kappelman mentioned the victim's family and the people who would be, the room that would be there. And the judge said, yes, I'm going to set aside space for you. And so then Donna's attorney says
we
that
need space for our client's family and friends who are going to be coming to support her as well. And we would request that they have similar priority seating as the victim's family.
And so the judge, in fact, says, all right, and gave them 2 rows right behind the defense. So Donna will have 2 rows, as will the victim's family, right behind the prosecution. So I don't know who that will be. If you know who will be coming, please let me know. Put it in the chat or in the comments. I'm really curious who will be coming on behalf of Donna and sitting there on the defense side. I don't know. Charlie's in jail. I doubt Wendi will. She didn't come at Charlie's trial. Harvey, I can see Harvey. We'll find out. All right. So we'll go into some questions. If you have some questions, if you would put question marks at the beginning of your question, put it in the chat, then I will look through those. But let me, there are a few people I want to thank. 1776 daughter. That's a good question. Okay. She's asking, am I going to live stream the trial? I have never done that before, but yes, I am really thinking about it. I think I am going to live stream the trial. I don't know if I'll be able to do that or not. I'm not really a spur of the moment person. I'm a prepare and get everything organized kind of person. So I don't know, but I think I'm going to do it because I think it would really stretch me, make me do something. Like one of the things that I really enjoyed about the Brooks Hout trial was when I did the lunch live stream. Okay, that's way outside my comfort zone, right? I just got live. Here we are. I'm talking like, So I think I probably need to do this just to grow as a person. I think it would be really interesting. So I'm thinking very seriously about that. If you have some feedback for me, put that in the chat or the comments. I'd appreciate it. Okay, Pippa, thank you for gifting a lawyerly membership. Very much appreciated. By the way, we will be doing another members only next week. All right, Elizabeth, may the scales of justice get Wendi. She may be next in line. A lot of people wondering. The prosecution has called her repeatedly a co-conspirator. So that's what they think. But no charges at this time. Mildred, just Mildred. Nothing says I didn't do it like a one-way ticket to Vietnam. And so I do think it's going to be very hard for Donna to overcome that. She has some good arguments if she was told that she could leave. But why did she need to leave? What was the reason for that? And I think her answer would be, well, if she, as a defense, would be, look, I already knew I couldn't expect a fair trial. I already knew my son had been convicted for something he didn't do. So why wouldn't I as well? Obviously, I better get out of here before that happens. So I think that will be the argument that she is very likely to make. Thank you. 1776 daughter gifting 10 lawyerly memberships. Thank you. We have so many new members tonight. That's wonderful. Be sure to turn on the ability to receive the gifted membership from YouTube, which decides on its own randomly who gets these. And if you're You can always subscribe by hitting the join button next to Lawyer Lee, unless you're on your iPhone, in which case you need to go on your computer or go through the browser. Okay, so let's go back and see what some of the questions were. Okay. Jenna wants to know, will I represent her if she ever gets into trouble? Jenna, you will not get into trouble. Listeners of this channel are not the type who get into trouble. So I'm sure you will not ever need that. All right. A fine, upstanding citizens is who we have here on the channel. That's who our audience is. All right. So I'm looking for question marks. Here we go. Louisa, when the bump was set up, were Sigfredo, Katie, and Luis Rivera already in custody or already convicted? So I believe the answer is that well, I don't know about Luis Rivera because he was initially picked up on another charge, right? So Katie, clearly not in custody because she meets at a restaurant with Charlie. So clearly not in custody. And I'm pretty sure she contacts Sigfredo, who apparently also was not in jail. So I don't know about Luis Rivera and whether he was in on another charge at that time or not. But great question. Lots of things we still will figure out over the next weeks. Okay, looking for those question marks at the beginning. If Wendi left the country now, would that be consciousness of guilt? So under the Freddie's cat asked that good question. Under the way the judge is ruling on this, the state could certainly argue that, and the state would be allowed to argue it. And Wendi could say, yeah, well, exactly what Donna will say, which is there were no charges. There was no arrest warrant. I was free to do this. It was my right. So you would have the exact same dynamics, I think, that you would have here. They would probably look at her computer and cell phone and see if she had done searches for non-extradition country and so forth. Like, is Vietnam still a non-extradition country? Ask ChatGPT. All right, let's see. Jilly May. So weird they would request priority seating for Donna when it doesn't seem like she has that much public or family support. Won't it be just that much more obvious to the jury that she doesn't? Great question, Jilly May. That is a great question. Clearly, if they aren't going to be able to fill it up, they would like to do one row and seat other people in that row. So it's not really clear that there are two people sitting on the aisle up there and then nobody on the next, row and 3/4. So that would look really like nobody's on her side. So I really do agree with you. I think that would be important. But they didn't so much ask for 2 rows as the judge said, that's what I'll do for you. So I don't know who, they might have plenty of people. I don't know. Just curious. Don't know who it would be. All right. Looking for question marks. Is Charlie paying the victim's family money? Not that I'm aware of. It's me, Jenny D, asked that. There's not been a civil suit that I'm aware of that would require that. Now, Charlie did have financial means at the time that he went into initially went in. But on the other hand, they've done a lot of stuff making plans to care for Charlie's child. So I don't know how much is left. I don't know if there's any intent to pursue him civilly for that. All right, let's see. I'm looking for question marks. Oh, I think I'm all the way at the end. So 1776 Donner says, we would all love to meet up with you each morning and spend the day in court with you. Well, thank you. I really appreciate that. I am really giving it some thought. Y'all would have to be very patient and gentle with me because I wouldn't really know what I'm doing. So y'all would have to be patient with me, but it would be a lot of fun. We would have a really good time doing that. Lisa S. gifted 5 lawyerly memberships. Thank you, Lisa S. So appreciated. All right. Well, I will see you all on Monday at 7 p.m. Eastern, and I will look forward to that. Thanks to our mods.